Mr. H, I heard some of the petitioner issue notice returnable in 3 weeks. Steps to be taken by Richard AD within 3 days. Yes, accordingly also.
My Lord, in respect of respondent number 2, my Lord, we have just been informed that this person had that we may be allowed to implement the NEET as well. My Lord.
Okay. Further prayed by Mr. Betala that respondent number 2 has since left office. He's allowed. He prays is allowed to correct the name of the course title in the course of the day. Yeah.
Highly obliged, my Lord. Grateful for that.
Item number 3.
This matter relates to that boxer matter, right? He was, we were required to find out the address of respondent number 3 and 4. My Lord, we have done it. In fact, they both, the office as well as the respondent number 4, my Lord, hails from Nongpo. So I have got the address, my Lord. May allowed.
You corrected, Mr.
Correct the cost title.
Thapa submits that correct addresses of respondent 3 and 4 since we received. We praise was allowed to correct the course title, indicate the
notice be also issued.
Accordingly, notice be issued to the said respondents. Yes.
All right.
Yes, so and so.
Item number 4.
Lordship, you may kindly take up this matter at the end of the board, Lordship. At the end of the board, Lordship.
Yes, I couldn't hear you.
Lordship, may kindly take up this matter at the end of the board, Lordship. Learned DSJ is present.
Your Lordship, here petitioners are seeking parity with 1563 students who had been granted opportunity to appear in the retest conducted by the NTA on 23rd of June, Your Lordships. Similar
the matter was
request
taken up by the Supreme Court.
Please, Your Lordships, kindly see page number 194. Your Lordships, page number 182 is the order dated 20.
184.
Your Lordships, page 182, Your Lordships. Annexure P24.
Yes.
This is the order dated 23rd of July 2024 passed by the Honorable Supreme Court of India, Your Lordships, in the lead matter writ petition 335 of 2024. The petitioners herein had approached the Honorable Supreme Court and, by way of writ petition number 381 of 2024, Your Lordships, and at page number 194, para 26, Your Lordships.
Yes.
Wherein our writ petition has also been mentioned, Your Lordships, writ petition 381 of 2024, 398, and
what
diary
relief
number.
Are you seeking here now?
Your Lordships, I am seeking relief of, I am seeking parity with the 1563 students, Your Lordships. First of all, Your Lordships, in this paragraph, the Honorable Supreme Court has granted liberty to the petitioners to approach the jurisdictional high courts, Your Lordships.
Yes.
So in this case, Your Lordship, what had happened, 5th of May 2024 NEET examination was conducted, and a discrepancy with respect to distribution of the question paper took place, Your Lordships. Few of the students suffered wherein both the sets of question papers were provided, MNOP and QRST, both the sets of the question papers were provided to the students. Few of the students suffered wherein one set of question paper was provided, and after a lapse of almost 1 hour, another that question paper was replaced by another set of.
What happened is 1563. They're allowed to take the retest.
Please, Your Lordships, all 1563 students were allowed to take retest on 23rd of June. Your Lordships, 6th of May.
But this order is passed on 23rd of July.
Your Lordships, 23rd of July is the different order which was passed by the Honorable Supreme Court of India, wherein the Supreme Court was taking cognizance of the matters pertaining to where there had been a widespread leak and where there was a systemic failure in conducting the NEET examination. There, the Supreme Court, Your Lordship, was considered whether re-NEET should be taken place or not. But here, Your Lordship, these 1563 students were allowed to take the retest on 23rd of June of 2024 because of loss of time, Your Lordships. This is relevant. So loss of similar requests were made by the petitioners also, Your Lordships.
So you want a special exam to be held for how many students are here?
Your Lordships, here there are 10 petitioners, Your Lordships.
10.
But almost, yes, Your Lordships, but almost more than 400 students had appeared from the centers Nongpo and Jowai, Your Lordships. Your Lordships, kindly see page number. Your Lordships,
okay, where's Dr. Mojika? He's come to court.
Lordship, he's on legs, Lordship.
He's come to court.
Yes, Lordship.
No, but today we can't do anything. We'll issue notice.
Lordship, he has some submissions to make.
Yeah, submission. Okay.
Yes, Lordship.
We'll take out some time.
Please, Your Lordships.
Item number 5.
I withdraw, my lord.
Will impose
Yeah, I've
cost.
taken instruction here.
Will it impose cost? What to do? But he's a laborer, no?
He is a illiterate man, your lordship.
Okay. DK Datta submits that instructions he may be permitted to withdraw the instrumented application of Mr. S. and Leonard Counsel for the respondent number.
405.
So 5 is present, has no objection. Accordingly, matter stands closed and withdrawn. Yes.
I'm appearing for respondent 3.
Okay, yes.
Pleasure.
He was not aware.
He was not aware. He was only paying money to somebody who was collecting money to file the cases.
And he signed the wakalat also.
Yeah.
He wasn't aware of the outcome also.
Yes.
Then how did he know to come to you personally then later on?
Somebody introduced me to him, your lordship.
And he said that file a case.
Yes. And he gave me all the papers, but this paper was not given.
This is not good form. Lawyer should be aware also.
Item number 6.
Just because he's that from that post, I mean lower post, we're not imposing cost. It calls for imposing of heavy cost. Yes, Mr. Chakraborty.
This is that matter, my lord.
Yes. R.Y. Ganu.
Ganu. Here, my lord, basically the order which is impugned is the order dated 24/11/2021 of the additional district judge in the Miss case number 1 of 2020.
Yes.
That is at page 65, my lord.
Yes.
But here, my lord, the Honorable District and Sessions Judge, that if your Lordship comes to page 69,
Yes.
second last paragraph, my lord.
Yes.
From above provisions, it's clear that an application under Section 8 of the Arbitration and Conciliation Act has to be filed vice or instead of written statement, and in support of this view, guidance is taken from the interpretation by the Honorable Supreme Court ruling in Rashtriya so-and-so versus so-and-so. Now, next page, my lord. From the above observation, to file application under Section 8 not later than the written statement, if not expressly but impliedly, it's clear that the application must be filed instead of written statement before the trial court where the suit is pending. And it is admitted fact that the petitioner defendant filed the application purposely before this court and not in the suit before the trial court, even though it is an objection to the suit.
Yes.
Now, this was the finding, my lord, that it has not been filed in the trial court. The contention that application under Section 8 lies only to this court of the additional deputy commissioner in scheduled areas being equivalent to district judge, which is the principal court as defined under Clause E of the Section 2 of the Act, is but a misleading fact, as the court defined in the provision refers for the forum of appellate court. In support, this court will take alike guidance from the Honorable Supreme Court's ruling in so-and-so versus so-and-so, reported in so-and-so, and the same is represented. In the premises, having not touched on the merit of the application but so far on the preliminary issue of jurisdiction in filing the application under Section 8 of the Arbitration and Conciliation Act before this court is found not maintainable in its present form, liable to be dismissed. It is also found to be misleading when it was filed by the written statement which should have been filed before the trial court where the suit is pending, thereby wasting the precious time of this court. As such, the application is dismissed with a cost of Rs 50,000 only, which is to be deposited within 1 month from today to the District Legal Services Authority for Welfare Fund. So this is the order which is assailed before your Lordship. Now, my Lord, our contention here, my Lord, is that when the Section 8 petition was filed, at that time it was pending before this Honorable Court of the Additional Deputy Commissioner. But, as it was, in this particular suit, what has happened, initially the suit was filed in the Court of the Additional Deputy Commissioner, and instead of endorsing the suit to some subordinate court of assistant to the GC, the Additional Deputy Commissioner himself took the case. At that time, the separation of the judiciary had not yet taken place. So the initial orders were passed by this Honorable Court only. And while the matter was still pending before this Honorable Court, this application under Section 8 of the Arbitration was filed, my Lord. So that is why it came before this Honorable Court. Now, in the trial court, the Court of the Assistant to DC, the notices were issued much later. That means the endorsement to the court was done much later, apparently, my Lord. So this application under Section 8 also should have been sent together, my Lord. Where it was not sent together, it was kept pending before this court, and it proceeded in this court. Even an objection was raised by the other side, my Lord. Still the matter progressed, my Lord. And finally, my Lord, the Honorable Court found it that it was not done correctly and imposed the cost, and also filed dismissed the petition without going into the merits of the matter. So, my Lord, we are aggrieved. If I can give your Lordship the dates, my Lord, then of course it will be clear. My Lord, on 10th August 2020, 10/8/2020, the Court of the Additional DC, and this particular court, issued a notice of temporary injunction to the petitioner.
You filed a suit?
No, my Lord.
I filed a suit.
You filed a suit?
My Lord.
You filed the Court of Additional DC?
No, that is the normal procedure. It is done and it is...
No, I'm just taken up Additional DC itself.
That is what has happened, my Lord. Instead of endorsing the matter was taken by the Additional DC. That is what has happened.
Yes.
Which probably was not the correct... In fact, my Lord, at that time the separation of judiciary had not yet taken place. So it was on 10/8/2020, my Lord, this notice of temporary injunction to the petitioner was issued.
Yes.
The next date fixed was on 10th of September 2020, before this Honorable Court only. On a day before the next date, that means on 9/9/2020, the petitioner's application under Section 8 of the Arbitration and Conciliation Act was filed. So that is, instead of the WS application under, there was nothing wrong in that, Lord.
Yes.
And it was registered as a separate miscase.
Yes.
And Miller, thereafter the matter proceeded. On 9th of December, the respondents.
Where's the application of Section 8?
Madam.
Page 28.
effectively from 29 million. Miller, because there have been number of agreements, Miller, all that, if I have to take your lordship through this petition, Miller. Miller,
Okay, just come to para 6.
6
at
minutes,
page
yes.
32.
I was coming to para 6 minutes.
Yes.
Miller. It is appropriate to mention further that the settlement agreement dated 31/8/2018.
So you tried to come to a settlement, but it didn't work out.
No, settlement done, Millets. Here what had happened is, Millets, there was a loan taken for Millets, there was a facility agreement. Under that facility agreement, Millets, certain amounts were to be paid. That was subsequently renewed, Millets. The amount as agreed between the parties has been paid. Now, after the payment of the money, Millets, it is the claim of the respondent before, as against me, that you have not paid the entire amount. You misled me into paying a smaller amount, and so there is a larger amount to be paid, and therefore the shares, my company shares, are withheld by them. So we are saying that in terms of the agreement, my lords, whatever was due, I have already paid to you. You've received it, but
That's good,
you are
that's
not releasing
arbitration,
it.
yes,
That's on the merits of the matter.
My lord. So, my lord, what has happened to answer, that is answered, my lord, the point raised by my friend of the other day, that no arbitration agreement is there. Now, my lord, it is appropriate, para 6, my lord.
Yes.
It is appropriate to mention further that the settlement agreement dated 31/8/2018 is just an extension of 3 facility agreements. The opposite party plaintiff, fully knowing the settlement agreement's recitals, saved the clauses of arbitration of facility agreements itself, invoking the arbitration clause by approaching defendant petitioner to settle the dispute via mediation, but its efforts in vain. The opposite party plaintiff could not approach arbitrator as the right of appointment of sole arbitrator was vested with the defendant petitioner. Hence, plaintiff filed this suit and miscellaneous application and prayed reliefs before this honorable court. The opposite party cannot invoke clauses of the facility agreements as per his own convenience and cannot invoke any clause partially. As the opposite party plaintiff proceeded and has chosen for amicable settlement via mediation, and the same when failed as contended, the next remedy available is only through arbitration. An appointment of arbitrator shall be made by petitioner defendant. The suit in hand therefore is incompetent. Now, my lord, what is being attempted to state here, if I have understood correctly, my lord, is that initially there were 3 facility agreements. Now, those agreements contain the arbitration clause. And pursuant to those agreements, my lord, this settlement was worked out. So when this settlement was worked out, thereafter, and an agreement was entered into on this settlement being worked out, my lord. So this agreement it is a continuation of the earlier agreements. So the specific clause for appointment of arbitrator
It's saved, you mean.
is saved. That is our submission. That is our submission. And it is also appropriate to mention that para 7 million.
Yes.
It is also appropriate to mention that there is also a clause which survives the indemnity and miscellaneous clauses in all the 3 facility agreements executed by the parties mentioned aforesaid. But the miscellaneous clause, there is subclause 21.7 which protects the arbitration and jurisdiction clause even after termination of final settlement or facility agreements. The relevant para of all the facility agreements dated December 16, 2011, February 9, 2012 and September 28, 2012, clause number 21.7, which reads as follows. Any expiry and termination of this agreement or the release of any securities on the occurrence of the final settlement date or otherwise shall not affect the provisions of this agreement which customarily survives such termination and or release, in particular clauses, indemnity and miscellaneous which shall survive expiry or termination of this agreement and or the release of any security. Now, my lord, this is what has been pleaded in the application for appointment of arbitrator. My lord,
Yes.
just in para 7, my lord, in the lower portion, your lordship will find that there is a subpara A and subpara B, my lord.
Yes.
My lord, under subpara A, it says that under the miscellaneous clause, there is a clause number 21.1 relating to jurisdiction, which describes that any suit, action or proceedings, courts of Mumbai shall have the exclusive jurisdiction. Now, B, there is a clause 21.2 arbitration, which describes that on failure of the parties to settle the dispute amicably, shall be referred to the sole arbitrator appointed by the lender, and the arbitration shall be held in Mumbai
Yes.
on the aforesaid ground itself. The suit and miscellaneous are liable to be dismissed. So, my lord, our submissions before your lordship is that regarding arbitration, my lord, is that the arbitration clauses have been saved,
Yes.
and since it has been saved, so, my lord, it still applies,
Yes. Open, yes.
and therefore we have prayed that the matter be referred to arbitration. Now, and as far as the order impugned in this, my lord, because, my lord, the honorable court below, my lord, the honorable court of the additional deputy commissioner, has erred, my lord, grossly erred in arriving at the finding that this was wrongly filed before this court. Because, my lord, the court in which it is to be filed is the court in which the suit is pending.
Right.
That is the definition of the court is that, my lord. Suit is pending. So at that relevant point of time, the suit was pending in the court of the additional deputy commissioner only. So in view of, my lord, this impugned order is to be set. So my lord, my submission before your lordships now, my lord, if your lordship is pleased to go ahead with the appointment of the arbitrator, referring the matter to arbitrator, that of course, my lord, is there. That option is there. But primarily, my lord, our grievance is by the impugned order, and
So we'll have to address impugned order first.
my lord, impugned order needs to be addressed, my lord, because that has to be set aside, and that cost also has been imposed, my lord. If that be set aside, then the matter be sent back, my lord.
Have you already paid the cost?
No, there was a stay of this
Okay.
from when we approached it. So, my lord, the thing is this, first, after dealing with that impugned order, my lord, after that your lordship would consider the next subsequent step, that whether the matter is to be referred to arbitration from here only, or the matter is to be sent back to the court below.
This is under 227?
This is under 222.
227.
No, it's under Rule 27 of the Administration Rules.
Read with me.
Read with 27.
Yes. Yes, Mr. Paul.
This is basically the premises.
It's limited issue. What had happened is, as my learned seniors already pointed out, application was filed by
Only one
them
thing,
as-
was the arbitration clause saved or not?
Well, it's not saved. It's not
then
saved.
that matter have to be remanded back for argument.
Well, that has to be decided by the court where the Section
suit
8
is
application has to be.
pending,
Well, what we were submitting is, that once the Section 8 application came to be filed before the additional deputy commissioner, even conceding to the fact that it was filed during currency of that matter before the court concerned, Subsequently, my lords, we initially filed a show cause. Then we again filed another application, my lords, clearly pointing out that the suit is pending before the Assistant to Deputy Commissioner.
When was the suit transferred to the
My lords,
Assistant
the
Commissioner?
suit is... I filed the entire order sheet before your lordships, my lords, by way of an additional affidavit. It is transferred on the 7th of October 2020.
Okay.
At page 4 of the additional compilation of order sheets, my lords.
This is the one?
My lords, that is
Oh,
the
yes,
one.
yes.
Lordships, can you have a look at page 4?
Yes.
The case is transferred to the court of so-and-so, DS Marbenang, for disposal.
Right. We'll pass orders in.
Well, it's only one thing that I must point out.
Yes.
Is, my lords, after we filed the application pointing out, my lords, that the suit is pending before the Assistant
They
to Deputy
persisted with
Commissioner.
it.
My lords, the petitioner insisted that the additional Deputy Commissioner take up the matter, my lords, which is what probably resulted in the costs being imposed.
Okay.
Because otherwise there was nothing, my lords. We would have simply said that let the matter be decided by the Assistant to DC.
Honestly, it's been held up in this court, honestly, because you two were working on a settlement and,
We tried, my
running
lords, it's
around
not...
a garden like in the Bollywood movies, like, and nothing came out of it. We'll pass orders, yes.
My lords, obliged.
All right.
Item number 7.
Yes. Yes, today ready at 2 o'clock?
Your
For
Lordship,
deposition?
I may be allowed to file an application seeking leave of this honourable court for withdrawal of the election petition, Your Lordship.
Why you want to draw?
He had
After
some
you taken this court to such pain,
he had some personal reasons, Your Lordship.
is he contesting the by-election?
I don't know, Your Lordship. No idea.
See, withdrawal also is a different kettle of fish, election petitions. It's not so simple as withdrawal of one ordinary petition. I guess the RP Act. Section 109.
Yes, Your Lordship.
Who's for the other side? Do we need to publish an official gazette or not necessary for hearing on the withdrawal?
It's not necessary, Your Lordship.
So to hear the other parties also in withdrawal.
Today I have no instruction, Your Lordship.
So what we'll do is we'll take note of the application.
Let this matter come up at the end of the board, Your Lordship.
End of the board.
Yes.
Yes, end of the board. We'll do one thing. We'll take it up. Let us here come tomorrow. This is an application under section 109.
That one, that application is seeking leave of this court, Your Lordship. The withdrawal application is here.
Yes, this application, that's what we will fix their matter.
Yes.
This is an application under section 109 seeking leave of this court for withdrawal of the connected writ petition. Stop. The application is allowed to be filed. This is the matter for consideration on 7th August.
Much obliged.
Item number 8.
Yes.
I am appearing on behalf of Senior Counsel Mr. B.D. Kuvar, Your Lordship.
Mr.
B.D. Kuvar.
Vidit Kumar, yes.
Yes, Your Lordship. As per the last order where the appellant has to deposit a 50% of the cost amount before the registry of this court, Your Lordship.
You deposited? Yes. Where's the deposit? Proved over some so rupees on that deposit. Yes, it's already been deposited on 2nd. So admit of consideration, call for the records. Yes.
Since they have complied, Your Lordship, then give us, yes.
Yes.
We'll file our objection, Your Lordship.
What objection in the appeal? It's heard.
Lordship,
There was a legal counsel for the appellant submits that as per the court's order dated 1/7/2024, check rupees 1.5 lakhs has been deposited by the appellant before the registry. Accordingly, we won't call for the
records have already been called for.
Already come, right? Proceedings, the main title suit shall continue. You don't proceedings in the only records of miscase.
My lord.
No, records of miscase are on. It's not the main. We didn't call for records of main title suit.
No, my lord. Only the records of miscase were called for.
Yes. As the Mrs. case records have already been received as a matter of admission hearing on?
After 3 weeks.
After 3 weeks admission hearing. Yes.
Lordship, may give us any particular date after 3 weeks? Any date?
After 3 weeks, you check it up later on. Yes.
Oblige, Your Lordship.
Item number 9.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
How much time? 4 weeks' time?
2 weeks' time, Your Lordship. Because on the last date, we just enter appearance, Your Lordship.
State file? You won't be filing?
After the municipal board.
After the?
Municipal board is the main accused.
What's this main accused?
Non-payment of salary, Lordship. Non-payment of salary.
Yes,
Lordship Bakmari.
Sad story. Keep on praying. Just further 3 weeks' time as prayed allowed for affidavit by Respondent 3 and 4.
Much obliged, Lordship.
I doubt if any affidavit will come also.
Item number 10.
This Lordship.
Does anybody there in the office, Bagmara Municipal Board?
Yes.
There, work every day.
Also is there.
Are you working every day also?
Yes. We are also working there also.
You're working as what?
We are regular employee actually. We are the grade.
What is your post?
Grade 3, like
what's your charter of duties every day?
Yes, Lordship.
What is your duties that they give you every day to do?
Duty, we are sometimes we are cleaning those.
Cleaning what?
Cleaning and then there are so
Cleaning
many other. Cleaning the town.
In the town.
But then we are regular employee. We are regular employee.
No, but do you get duties through every day or?
Yes, we get duty every day. Every day we are going to do the work.
Every day you
without
go.
absent. Yes.
Can we call for attendance?
Yes, it is there, Lordship.
To see.
It
Every
is
day you're there.
Every day, attendance also is maintained.
Know what duties are done because I am a frequent visitor to Bagmara. I just want to see the faces of these people also, who are cleaning the town
Yes,
every day.
Lordship. Actually, I'll explain on the next day. But we are regular employee, and then they are not denying that also.
So what time you go to work when you go to?
10:30.
10:30. What do you do first?
Then after 10:30, then we leave by as officer as regular by 5:30.
You clean the town. Cleaning the town done only early in the morning.
Many other
Never
things
at 10:30. Yes, okay, we'll see. Because this Bagmara has become a very sad story. People is claiming salary, don't know whether any work is done.
Yes, because the government has sanctioned, we have enclosed the money also. The money is there also.
Yes, money is there.
Much obliged, Lordship.
Yes.
Item 11.
Yes, Assalam.
Your Lordship,
Has
affidavit
been
will be
filed?
filed in the course of the day.
Has
Your
been filed?
Lordship. In the course of the day, Your Lordship will file.
You're for the petitioner. Who's for one and who's for number one?
Corresponding bond, Lordship.
One is Mr. Devnath. You're filing affidavit.
It's just a formal party, Lordship.
Your formal party. Yes, MS S. Salam submits that the affidavit on behalf of respondents
2, 3, and 4.
2 to 4 shall be filed in the course of the day. MS so-and-so submits that as for number 1, as only formal party, no affidavit forthcoming from this respondent. Yes, list after 2 weeks for rejoinder if any.
11.
May this is Lordship. Lordship, we are filing the affidavit in the course of the day.
What's happened? Why is not just give them materials? Carry on the proceeding.
Your Lordship, even this is the same prayer before
Why should they come here?
This is the same prayer, Lordship, everywhere before the division bench also, before the inquiry officer also, and then they file this petition, Your Lordship.
Your Lordship,
You not got the materials till now.
You're also asking for enhancements of subsistence pay.
No, have you got your other materials or not?
We have not received completely, Your Lordship.
What do you mean? Which ones are missing?
I've no instructions.
Well, direct from by order of the court. So and so, whatever you feel that's not been supplied. But we can't hold up the formal proceeding. Yes, course of the day.
Course of the day, Lordship.
Ms. ND Shura Leonard AAG so submits that the affidavit will be filed in the course of the day. Just for further orders and so and so.
Oblige, Lordship.
We'll dispose of next date, Mr.
Lordship, yes.
12.
We are praying for some time, my lord.
Your Lordship, I need some more time, Your Lordship, to obtain the status report from the
Respondent number?
respondent number 3, Your Lordship.
Mr. Kiwaji, please funds allowed 2 weeks further to send file affidavit. Staff MS and Raji submits that she may be also allowed similar time to obtain status of service on the respondent number 3 and to file service affidavit. After 2 weeks, yes.
Much obliged, Your Lordship.
13.
Also.
Your Lordship, in this matter, we'll be filing the affidavit in the course of the day, Your Lordship.
Already filed. Won't be filing. Why? Who's number 4?
Lordship, our affidavit is not required. Lordship, the last time, the issue raised here, Lordship, with regard to the not giving opportunity to the petitioner before passing the impugn order. So therefore, the records call from the GHADC, their affidavit is enough. We'll rely on that.
Okay. Ahmed Aji submits that after in behalf of respondent 124, you file the course of the day. Stop Mr. S.K. Hassan appearing for the respondent number 5 submits that no affidavit will be necessary from the said respondent as necessary materials are already enclosed in the affidavit of the official respondent. Yes. Just after
1 week, my lord.
For rejoinder, if any.
Much obliged, Lordship.
14.
Yes.
Your Lordship, I'm praying for some time to file our affidavit in opposition in this matter, Your Lordship. On behalf of respondents 1 to 6.
What's the matter about?
Your Honor, this is we file a WPC for misappropriation of the funds.
Whose funds? VC. VC.
Yes, Your Lordship.
Usually very prompt. How come asking for time?
Your Lordship, we've just received instructions.
Yes. As prayed for further 2 weeks' time on behalf of 1 to 6 allowed for affidavit. What about the other respondents?
Other respondent, Lordship, we have already sent the notice till date 18 April. They have received the
They've
notice.
received?
Yes, Lordship.
15. 15.
Obliged, Your Lordship.
My lord, the respondents are yet to file their affidavit.
My lord, on behalf of the state, my lord, I'm praying for some more time. My
This-
lord, instructions we've received, my lord, but some clarification is there.
What's the matter about?
This pertains to non-payment of salary, my lord. I was
You're a teacher?
teacher, my lord, since 2000, August 2022. I've been
You've not been paid?
No, my lord. Of course, my appointment and others' appointment are under challenge before this court, but there is no stay order, and we were not being terminated. We continue to serve the school, my lord, till today. And in fact, there was one occasion also where my lord has directed the managing committee to pay the salary if applicable, my lord. Now, the purpose for me to come before my lord is because there's
a linked to the other one, the other case.
I'm sorry?
Is it linked in any way to the other case that's pending? Challenged your appointment?
Yes, they have challenged the appointment.
Your
in that
appointment
one.
also?
My appointment also. They challenged the appointment. But there is no stay order. Therefore, we were allowed to continue to teach.
Whatever, but is it connected? The facts, are they intertwined or not? This case and that and the
No,
challenge?
it's not.
They're
This is
separate.
purely, I'm just asking, whatever I'm teaching, pay me.
Yes, Mr. Bhattacharya. Who's appearing at the matter? You're appearing?
Well, at the matter, I'm not appearing.
Yes, further 2 weeks' time as prayed. After state response file affidavit. Yes.
Right.
16.
So sometimes orders are passed one case, it doesn't impact the other case. So you have to be sure.
In this
You
one, it
check
will
up
not
the other matter.
Yeah, my lord.
May I please, Your Lordship? In this case, Your Lordship, I have already prepared, but I need some more time for correction, Your Lordship. 2 weeks' time may be given.
2 weeks' time for correction?
Yes, sir, because 21 in excess, Your Lordship. This is for promotion of the ICDS employees under the Social Welfare Department.
How many petitioners? 76 petitioners? 77? Further 2 weeks' time as allowed to respondent number 3 to 6.
3 to 6, Your Lordship.
What about you? No affidavit. So submits on behalf of, it's already recorded earlier that you won't be filing affidavit.
Yes, recorded.
Much obliged, Your Lordship.
17.
We have respondent number 6 and 7, my lord. We have received the notice. We are entering appearance today, my lord. Kindly allow us just 3 weeks' time to file our counter, my lord.
You're 6 and 7.
6 and 7, my lord.
Appearance today on behalf of respondents 6 and 7. And as such, notice is complete on all the respondents. District Council where? Is the affidavit necessary in District Council?
Yes, Your Lordship.
No one today with District Council. What about you'll file affidavit? None appears for response 1 to 4. Mr. Jirwa on behalf of respondent 5 and Miss and what about 8 to 10? No appearance also. No state 8 to 10.
Yes, Lordship, it's the state.
You are appearing.
Performer respondents. Yes.
You are appearing. You won't file affidavit.
No.
Yes, none appears for respondent 1 to 4. Stop. On behalf of respondent number 5, Mr. Dear Praise 4 is allowed. How much time? 3 weeks time to file. 2 weeks time to file affidavit. Similar prayer made by Mr. Yobin for respondent 6 and 7. Stop. MS S. Sham on behalf of 8 to 10 submits that
Lordship.
as a pro forma parties. Oh, you're here.
Yes, Lordship. Special respondents 1 to 4, Lordship.
You won't file
We
affidavit.
will be filing affidavit, Lordship.
Support of the so Mr. Pubins under appearance behalf on response 6 and 7. So notice is complete. Stop. Next paragraph. MSC non Cloud for respondents 1 to 4 and MSS Sham for respondents 8 to 10 submits that no affidavit before counting this respondent. Stop. Mr. Bujurwa for 5 and Mr. P.O. Bin for 6 and 7. Pray for allowed 2 weeks time to file affidavit. This is the afternoon. So.
Obliged.
18.
Lordship, I'm praying for further 3 weeks' time to file affidavit in this matter.
When does this file? Yes, 3 weeks further time as prayed. It's allowed.
Highly obliged, Lordship.
Alright.
Second call, item number 4.
Yes, Dr. Mozika. What instruction do you have?
Well, the instructions are, my lord, that in these 2 centers, my lord, Joai and Nongpo, additional time were given to the candidates, my lord. And that is born out of the inquiry report by the Deputy Commissioner, my lord, and also from the report submitted by the Center Coordinator, my lord, as this place is material.
Your Lordships, if I may submit.
Yes. Are you aware of this report?
No, Your Lordships.
Then
This
you
is for the
have to
first time.
I'll file an affidavit, my lord.
Let them find affidavit within 1 week.
Your Lordships, there is, yes, Your Lordships, there is only one request. The counselling is yet to begin from 14th of
The
August, Your
counselling cannot
Lordships.
be stayed, my lord. There is a counselling
No,
for
Your Lordships,
100,
I am not seeking
1 lakh
stay.
seats,
Your
my
Lordships,
lord,
I am not
all over the
seeking,
country.
I am not seeking stay on the counselling process, Your Lordships. My only submission is that the matter be disposed as early as possible, Your Lordships. I am seeking for the earliest date, Your Lordships. If 2 more days, Your Lordships, to be given to them to file the affidavit, Your
No,
Lordships.
let
because
them
this is
file within 1 week.
1 week.
We'll take it up thereafter.
Next
But
Monday.
Your Lordships, because
Yes,
Your Lordships, because 14th of August the counselling begins. Your Lordships, that is my only request.
Okay, third MS, what's her name?
Y. Pallavi.
Y. Pallavi, on behalf of the petitioner, stop issue notice. Dr. El Mozika is present on behalf of the respondent's number, NTA,
NTA as well as Union of India, my lord.
on behalf of respondent 1, 2, 3, and Mr. N.D. Shulai, AEG, for respondent number. Effect no further notice is called for stop
Your Lordships, the matter be fixed on 12th of August.
submits that the matter is of some urgency as it involves the dispute, the controversy with regard to the NEET UG exams. With regard to 2 centers, that is Joy and Nopal. Next paragraph, Dr. N. Mozika for the respondent 1, 2, 3 submits that he received instructions and prays have allowed 1 week's time to file an affidavit. Accordingly, this is matter.
Next Monday.
On next Monday.
12th of August, Your Lordships.
Next
Please,
Monday.
Your Lordships. Monday.
On 12th,
Please,
yes.
12th of August, Your
No
Lordships.
further orders, yes. Affidavit should be on board by the next date.
Obliged, Your Lordships.
We take it back.
In fact, in these 2 centers, my lord, there was some mix-up with regard to 2 sets of question papers, my lord. So
once there's a mix-up, students get totally confused. It's like it's very and whatever they've learned also sometimes it's they.
Your Lordships, if I may submit, there is an admission also on the part of NTA in their affidavit which was filed before the Honorable Supreme Court, Your Lordships, wherein they have admitted that there was a loss
too
of
late in the day, my lord. But the Honorable Supreme Court also refused to intervene in the matter, my lord.
Yes.
I'll file an affidavit.
Hearing, item 19.
Election was waiting to
Lordship, as for the last order, I have filed my written.
What do you file?
Yes, I find it whatever the points which I paid this ago before the. I have supplied a copy to.
So we'll close it.
Parties.
Yes,
Anything else you said?
Yes, Your Lordship, nothing to argue.
Yes. As Mr. P.T. Sangma has filed his written argument, as only in the prayer we allowed written argument. I don't quote doesn't want written argument. Yes, hearing is concluded, judgment reserved.
Much obliged.
Much obliged, Lordship.
Twenty-one.
Yes.
This is that appeal, Your Lordship.
Why did you request adjournment last time?
Lordship was not keeping well. I was not here.
Oh, you're not keeping well.
Yes.
Yeah.
So this matter was substantially heard before it was sent for mediation. But however, the parties could not settle. So
Sent mediation. When was it sent mediation? Last year or this year?
This year, sir.
Okay. Oh, it came back July only. Oh, yes.
Yes, during the mediation we have offered 6 lakhs, but we are not willing to accept.
Yes. Start. What do you have to say?
The main issue here is, Your Lordship, where the judgment of the learned judge, District Council Court, in one breath has stated that I am the legally wedded wife of the deceased person, but on the other hand has refused to give me even 1 rupees out of the benefit arising from the salary of the accused person, of the deceased person.
You filed revocation?
I filed for revocation. Actually, at first they filed for the succession if obtained, and after learning of the same, we had filed revocation, which was stayed.
Yes.
And then the matter went for evidence, and the impugned order was passed.
Yes.
I'll take straight away to the issues framed by the Learned Justice Council Court. It's at 61A of the paper book.
61A?
Yes, Lord.
Oh, you made a paper book?
Paper books.
Yes. Yes.
7 issues were framed.
My lord, before we proceed, can this matter be taken after 1 week, my lord? I missed out some points, my lord.
What points?
No,
You brought the wrong file?
No, prepared something, my lord, but I missed out something.
It was not there today, what you prepared.
I'm very sorry.
Okay, since you took Ajwan last time, we'll give him chances to him. Yes, Mr. Khasing expressed some difficulty as his materials prepared has not reached the court. It's a matter of 1 week. Yes.
Only thing left is to decide how much amount any
You
party.
take 6 lakhs. He's offered you 6 lakhs.
Your Lordship, here there's 6 lakhs because what we offered, Your Lordship, was that we will not claim anything, even the pension, which is like our right also, we'll waive it off. The only thing you give us is the areas that's accrued from the pension over the years. If they give us that, we'll give them everything else.
Arrears accrued from the pension over the
from
years?
2011
That comes
till-
how much?
It comes to around 10 lakhs, Your Lordship.
Then take 6 lakhs enough.
Your Lordship, if we consider, Your Lordship, she's a very aged woman and now she's suffering from
Take
high
something
expenses.
is better than get nothing.
There's some
You advise your client within 1 week. If it's only around 10 lakhs, if they're giving 6 lakhs, very fair. But even your case also, I
The
remember
areas
now,
is-
it's very difficult.
The areas is 10 lakhs, then the other benefits accrues to around 24 lakhs, Your Lordship. And out of 24, they're giving us only 6.
Okay, give 1 more lakh extra. Become like a negotiating, like a bargaining, like a shop.
22.
You talk. I mean, actually, the duty of you counsels only to try to settle that out of court. You know, sometimes parties don't understand, but then you have to talk.
This is the 3rd time we tried our best, but then
I'll try to convene again. Hello.
Yes. Objections been raised by Mr. Hazarika. What you ready with the matter?
Your Lordship, the conducting counsel has not reached yet due to some personal difficulties, Your Lordship.
Which person? Who's the conducting counsel?
Sir, M. Kurisi, Lordship.
Where is he? He's in court?
No, Lordship. At home, Lordship.
He's at home. What's he doing at home? On Monday morning. You are paying for the state. Where's the state?
I am for the state.
Oh, you're for the state. What's the urgency, Mr. Hazarika?
Here, my lord, they are asking the salary without attending the school. Since more than 3 years, not attending this.
I'm not ready to argue in matter at all.
No, Lordship.
Unless after 1 week, yes. Due to the absence of the arguing counsel. It's noted that the court had.
25. 25.
I don't know. Where's Mr. Shulai?
It's not here. As per the last order, Your Lordship, they have to take instruction.
Where's Mr. Shulai?
My senior can begin his.
No, it's only for instructions.
My lord,
Because
we have the instruction, my lord, but let Mrs. Shulai make his submission, my lord. My lord, your senior counsel on the last occasion make a submission regarding DPC, my lord. So, my lord, we have been there is a letter by the council, my lord, saying that no DPC should be taken up by the department, since there is a court has interfered with the entire matter, my lord, with regard to this particular category.
after order 23-7.
My lord, in the first round, my lord, from the first round, I see there is.
May it please your lordship. Lordship, this is the fourth writ petition. First writ petition was, that is writ petition number 292 of 2019. That was
1 second.
292 of 2019.
292
of 2019, your lordship. That was withdrawn on 8/8/2019.
1 second.
Lordship.
Then
another writ petition was filed, that is WPC number 303, your lordship, of 2019.
303.
Lordship, yes. Then that was disposed on 16/8/2019.
What order was passed?
Lordship, just a minute, please, your lordship. Where's the order? 16/8.
So immediately after withdrawal, they file a fresh one.
16/8. 16/8, where's that order? Where? No. No, it's not here.
Mr. Datta, you're a counsel all along.
Then, lordship, that order is not
Lordship,
here.
so far,
Then,
the instant
then
writ
lordship,
petition is concerned, I have not written anything, your lordship.
please,
those writ
please
petitions-
let me finish.
You're supposed to come in instructions, yes.
Then, lordship, then writ petition number 394 of
No,
2000.
how was it disposed of 16/8? What was the order?
Lordship, I don't have the order.
Then?
16/8. No, 16/8 is not there. 16/8. Lordship, it say like this. After the, that is the order. It say like this. After hearing learned counsel for the parties who are expressing any opinion on the writ petition is disposed of at the stage by directing respondent number 3 to take this decision on the representation, your lordship. Then, your lordship, a writ petition 394 of 2020 was filed, your lordship.
394.
394, your lordship. During this pendency, your lordship, during the pendency, your lordship.
2020.
Lordship. Huh? Lordship, the council, your lordship, submitted that letter. Submitted that letter. So, as a result of this letter, your lordship,
this was
in two people, your lordship, who were above him, your lordship, and other staff, your lordship, they were deprived of their promotion, your lordship, because no DPC could be helped, your lordship, because the department believed that there was the stay of the of DPC, your lordship.
Now, coming back to other thing.
Lordship.
2004, the DPC sat, correct?
Lordship, yes.
Recognizing other people. So
Lordship, yes.
Now, if you say the DPC is irregularly constituted, then what will happen to the other people?
Lordship,
that is
certainly it will affect your lordship.
Yes.
Certainly it will affect your lordship.
But no, but then what impact will this have? He gives letter, you should have disregarded it.
Lordship, because
there were no orders.
Lordship, yes. Because what happened, your lordship, it's also default with the department because it
So the thing
opinion
is
was
that
not
there are
for.
whole departmental.
Yes, Your Lordship, believing that there is a stay, Your Lordship. Believing
There was no stay, Your
there is
Lordship.
a stay, Your Lordship. Because can you see the sentence, Your Lordship, in the letter?
No, he says that
Lordship,
the
yes.
aforementioned petitions pending
Lordship,
for the
yes.
High Court as such will not be prudent to constitute.
Lordship, yes.
But
Correct,
to
Your
avoid
Lordship. Correct, Your Lordship. So, department believe, in good faith, Your Lordship, that there is a stay, Your Lordship.
Why do you write this letter, Mr. Datta, when the matter is
As a
pending
result, Your
before
Lordship,
the
so
court?
many people, they have been deprived of the promotion, Your Lordship.
Why was the letter written?
Your Lordship, it was written at the instance of my
The
client.
thing is that, Mr.
Yeah.
Datta, if you're a seasoned counsel, you do not go by advice of your client, because in legal matters, he just
Yes,
has
my
to give the facts.
Yes, my lord. Yes, my lord.
And whatever legal expertise, you're supposed to possess them. And in matters which are already pending before the court,
But
it's
this
not it is not prudent that you go and write letters
Yes,
to
Your
try to
Lordship.
influence
Yes.
the outcome
Yes, Lordship.
or proceedings.
These cases are disposed of, Your Lordship.
No, doesn't matter, but this has come to
it was
notice now.
disposed, Your Lordship.
And this issue speaks very badly of the conduct of not only the petitioner but of the counsel also. How can you agree to such a proposal by the client?
But so far the instant writ petition is concerned.
No. Don't come the instant petition, please.
Yes, Your Lordship.
When a court has put a question to you, is this a proper practice for a counsel to behind the back and write letters? If there's a stay order, you communicate them.
No, there was no stay.
Another matter, you know, here before this court, just improper interpretation status quo, this court came down very heavily.
Yes, Your Lordship. I apologize for that, Your Lordship.
Apologize doesn't matter. Now this is 22.
This matter was of 22, 19, 22, 21 and 22, Your Lordship. And these writs petitions were disposed of.
And people have been deprived because of you. They've been deprived of pensionary benefits. What harm have you done to them?
Yes, Lordship.
You give the names of those people who are affected.
Lordship,
They'll record it. Till after 1 week.
Lordship, yes. Then we'll do
today, Mr. N.D. Shulaland AAG has produced a letter received by the department on 19/12/1922, where it shows the conduct of the writ petitioner, wherein in the course of early writ proceedings, letter had been written, writ proceedings, namely WPC now 394/2020, letter had been written to stall developmental proceedings. The Constitutional Departmental Promotion Committee. Stop. Mr. Initially submits that due to this letter, the department was given to understand that holding our Department Promotion Committee would affect the outcome of the case. As a result, certain deserving people have been deprived of due promotion. Stop. He's directed to place the names of the people he states have been deprived. We'll take action, you compensate them.
Lordship. Highly appreciated.
You compensate them. Datta is here a seasoned counsel. How many years you practiced?
7 years, Lord.
No wonder. Were you working somewhere before?
Yes.
Where were you working?
I was the principal of Islamia Secondary School.
26?
You should know better, than to listen to clients. That's what we were taught even when we start practice. Yes. Yes.
Please, Your Lordship. This is against the issuance of.
Before my friend starts, here that private respondent, number 6, is being represented by Mr. Panthi. Panthi.
Where's Mr. Panthi?
Because her license is being put to challenge before the Honorable Lordship.
By Panthi?
No. The petitioner has challenged the license of the respondent number 6, Lordship.
Where's that respondent number 6? License? You're the Shinong?
No. She is the villager's Lordship.
You want to shift his wine store?
Your Lordship.
No. You want number 6 is whom? Owner of the wine store.
Yes.
You want to close his wine store?
Yes, Lordship.
It's closed, still open now.
No, open, Lordship.
It's open.
Then the most important respondent.
Yes, Lordship.
Where's
because
Mr. Panthi?
He's the affected. She's the affected.
We
Here
can't
we
go
have
for
very-
the matter unless he's heard. Again, they'll come and see we've not heard. Again, the whole matter we have to be heard.
Here the state has raised the issue of mental ability also and locus also because
No,
who is
number
she?
6 has to be there.
Later on, Your Lordship.
Dorbarshna Lumpulet is whom? Number 9 is whom?
Your Lordship, we have given notice to the.
Who's appearing with Dorbarshna? They gave NOC.
Yes, they have
Yes.
given
Who's
NOC,
appearing
no
for them?
objection. Your Lordship.
Let's see.
And the.
1 second, 1 second. 7 and 8. 7 and 8.
7 and 8.
This is a council.
Yes, Your Lordship.
Number 9 never appeared.
Number 9 is the Dorbasno.
What he served? Panthi for 6.
6.
Did he appear any time? Number 9.
Your Lordship, on the last occasion, this notice to be given to respondent number 5 and 6. Order was there, Your Lordship. But in case of this respondent number 9, I don't think so. There's such.
On the motion,
order
State
was
Lordship, notice was not issued, Lordship, because waiting for the counter from the State Lordship. Then
we have issued. We have.
then the State
no-
has filed the counter.
Yes.
Then the matter was proceeded for hearing. Then I have apprised the court, my lord, that notice was not served, not issued to the other respondents. Then subsequently, my lord have issued the notice
What are respondents?
to other respondents, including the respondent number 6.
Including respondent number 9 also.
Private lawsuit.
Your Lordship, in fact.
Which order? Let's see 1 second, Ms. Kyangti. Just 1 second.
Wait for my submission. Wait, just wait for my submission. Don't tell me what I have to submit.
Due to oversight, notice on this have not been issued. Due to oversight, notice on this have not been issued to respondent number 9. Moreover, the 9. Moreover, the respondent number 6 also is not present today. Next, accordingly, let's